When you look at the case that shocked the nation, the case of Hannah Clark, there were lots of things that were going on, and her family said in the inquest, we'd go to the police and they would say that it's not a crime to stop her from teaching a gym class. It's not a crime that he wouldn't let her wear the colour pink. It's not a crime that he needed to know where she was all the time. Those singular acts of their own weren't crimes. And so it's those build-up of lots of acts over a period of time created and curtailed the freedom of Hannah Clark and perpetrated upon her a type of intimate violence that New South Wales has said is now a criminal offence in its own right.
Welcome to Law for Community Workers. This is episode 4 of our series, Till the Violence Ends, where we share insights from experts in the domestic and family violence space. In this episode, Bridget takes a deep dive into coercive control with criminal lawyers Helen Shaw and Hayley Dean. This episode was produced on the lands of the Gadigal people, and we pay our respects to elders past and present. As we share in education today, may we acknowledge Aboriginal and Torres Strait Islander people as the first storytellers, lawmakers, and educators. As a reminder, this podcast is general information only and can't be relied on as legal advice. It's accurate at the time of posting, but may have changed if you're listening at a later date. If you or someone you know needs legal assistance about a particular situation, start with our team at Law Access New South Wales via web chat at legalaid.nsw.gov.au or call 1300 888 529.
Welcome, Hayley and Helen, to the podcast. Today's episode will focus on the topic of coercive control. But before we get into that topic, I'd just ask you both to please introduce yourselves and let our audience know a little bit about the work that you do.
Well, hi, my name is Hayley Dean. I'm a solicitor advocate in criminal law and an accredited specialist in criminal law. I've been working with Legal Aid New South Wales for 16 years, and prior to that, I was a prosecutor for the state and federal DPPs.
My name's Helen Shaw, Senior Solicitor in the Indictable section of Legal Aid in Sydney. I've been a lawyer since 1998 and at Legal Aid since 2003, practising in predominantly indictable criminal law matters, and I've also done a short stint in private practice prior to coming to Legal Aid.
Coercive control. How did we get here, and why is there now a new law that tries to deal with a pattern of behaviour that amounts to coercive control? What's the background to this?
Well, thank you, Bridget. It's actually not called coercive control as a piece of law in New South Wales. Its real name in the legislation is abusive behaviour towards current or former intimate partners. And the way in which this piece of legislation came about was actually as a result of the study of lived experience and statistics, and a lot of the work done with victim survivors, and also a lot of the studies of domestic violence homicides, which produced a number of different reports and found that the marker prior to a person being killed in a domestic violence homicide was the existence of what is described as coercive and controlling behaviours. So part of getting to understand how we get to legislation in New South Wales, and New South Wales is actually effectively the first state in Australia that criminalised this behaviour, is having a look at what existed before. And what existed before in the law was described as what's called incident model for domestic violence offending. And coercive control or abusive behaviour towards current or former intimate partners expanded this idea of domestic violence to cover a course of conduct or a pattern of behaviour. And so an incident model is when something's happened on a specific day at a specific time, like a punch in the eye or breaking of a mobile phone, that singular thing that happened on that day, that incident. But the study of domestic violence survivors produced a large amount of literature and empirical information that explained in the majority of domestic violence settings, the abuse is ongoing, long-standing, and constant. And it's that pattern of behaviour that is in many ways far worse than the singular incident of domestic violence. And so the work of a large number of stakeholders, victims' representatives, Aboriginal and Torres Strait Islander representatives, lawyers, and the government worked together over a period of time to figure out a way to look at this course of conduct of offence being a criminal offence in its own right. When you look at the case that shocked the nation, the case of Hannah Clark, there were lots of things that were going on, and her family said in the inquest, we'd go to the police and they would say that it's not a crime to stop her from teaching a gym class. It's not a crime that he wouldn't let her wear the colour pink. It's not a crime that he needed to know where she was all the time. Those singular acts of their own weren't crimes. There was no crime for that. And so it's those build up of lots of acts over a period of time that created and curtailed the freedom of Hannah Clark and perpetrated upon her a type of intimate violence that New South Wales has said is now a criminal offence in its own right. So I guess that's a very short way to describe how we got here. We've expanded the concept of what domestic violence can be in the criminal law.
Thank you, Hayley. There's a quote that I know you've both used in some of the education work that you've done with community workers that says coercive control is a pattern of behaviour by which the autonomy of a victim survivor is eroded through behaviours that are psychologically, emotionally, financially, sexually, or physically abusive, intimidating, or violent. And another quote that says coercive control is a form of domestic abuse and is a precursor to domestic violence death. Can you tell us about that connection between what's referred to in that quote as coercive control and domestic violence death?
Well, the studies that were quoted by the Attorney General at the time when this act was a proposed bill, they lent on the data that had been collected by the Domestic Violence Death Review Committee. And the committee gathered up the background circumstances of, I think it was about 119 domestic violence homicides over a period of time, finishing in around 2019 for the 3 years prior, I think from memory. And they found that in all but one of those cases, so that's like a 99% ratio, coercive control happened. And it happened at quite an increasing level and at quite a proximate level just prior to the homicide occurring of the person. And so when people die, there's many reasons why inquiries are conducted into the deaths of individuals, and these are led in the coroner's courts, but they're also led by, in some instances, royal commissions, and then in other instances by a body like the Death Review Committee. And they look at the reasons or the ingredients into why certain things keep happening that result in people dying. And the data, when that inquiry was made, it spoke, and it spoke with complete clarity that coercive control is a precursor to domestic homicides. So the government decided to do something about that.
The government has done something about it. Can I ask either of you to speak about what the law says in the way that it creates a new offence?
Section 54D of the Crimes Act sets out the ingredients or the elements of the offence that the prosecution must prove beyond a reasonable doubt in order to get a conviction for this offence. So, Section 54D, the subtitle of that is Offence of Abusive Behaviour towards Current or Former Intimate Partners. An adult commits an offence if A, the adult engages in a course of conduct against another person that consists of abusive behaviour, and B, the adult and other person are or were intimate partners, and C, the adult intends the course of conduct to coerce or control the other person, and D, a reasonable person would consider the course of conduct would be likely in all the circumstances to cause any or all of the following, whether or not the fear or impact is in fact caused. 1, fear that violence will be used against the other person or another person, or 2, a serious adverse impact on the capacity of the other person to engage in some or all of the person's ordinary day-to-day activities. and the maximum penalty is 7 years imprisonment.
The section refers to intimate partner. Is intimate partner defined, Helen?
An intimate partner can be a de facto, can be a husband and wife, or a past de facto or husband and wife. It does not include people in the household or every person in the household, however.
It can include same-sex marriages. It doesn't envisage parents and children, but it does envisage people who are at least dating.
So the definition is in the legislation under section 54C of the Crimes Act. There is definitions for intimate partner and also definition of adult in the Crimes Act.
And Helen, when you spoke about the way that the legislation is set out, you talked about a requirement of intent, that the person intends to coerce and control. So I imagine that makes it slightly more challenging to provide evidence.
Evidence, that's something that's really important for somebody wanting to bring a charge or to go to police with this, collecting examples which may prove not only the actions, the comments, the words, the abuse, but also those examples may help demonstrate what the person's intention probably was, or help draw inferences, because in law we deal with inferences. Sometimes the person doesn't explicitly or specifically say, I intend to hurt you, or I intend to deprive you of all your earnings, or I intend to do something. They may not use the word intend or intention explicitly, but you look at the behavior around what's happening. You look at the lead up, you look at the consequences, you look at the words around it, text messages, emails, and to try to build what their intention must have been.
And another way to look at that is also from the reverse. Like when you look at it as a non-lawyer, when a charge has intention as being one of the ingredients, that's quite a higher level of proof. Whereas, you can accidentally hit someone with a car and still be at fault. We don't have that level of proof that you've accidentally intimidated someone, you've accidentally controlled them. So it's much higher than an accidental level of fault. It's also much higher than being reckless as to the impact of your conduct. So another level of fault in law is being reckless as to what you're doing. So I did what I did and I didn't care whether or not it created a result, is the reckless standard. But this offence has the standard that the person doing it has intended that their actions will coerce or control the person that they're doing them to. In order to determine whether or not that intention has been carried out, the court often will, as Helen has described, will look at the behaviour. And very often the behaviour speaks for itself. When you send someone a text message saying, get home or I'm going to hurt the bird or the dog, that text message is very clearly being sent with the intention of forcing that person to get home. It's quite a clear level of intention that can be inferred from that behaviour. But the standard for this offence is intention, and one of the areas that the lawyers debate about is that too high a standard? Should it be reckless? But the legislature has called it intentional offending at this point in time, and we're going to see how that plays out.
What about a defence to this new offence?
So that's section 54E of the Crimes Act, and which reads as following. 1. In proceedings for an offence under section 54D, subsection 1, it is a defence if the course of conduct was reasonable in all the circumstances.
I guess a way to just figure out whether something's reasonable is usually, is it necessary? Is the question you ask yourself. So the example often quoted here is that, let's say, for example, there's a couple and the relationship's not doing so well, and one person in the couple is using the pooled family funds to gamble and drink and maybe possibly buy drugs as well. So the other person starts taking control and being very restrictive of when that other partner in the relationship can access the funds. Theoretically, that could be alleged as a form of coercive control. But in this specific example, there's the potential to raise a defence. It was necessary. It was reasonable in the circumstances because they were gambling the house and we had nothing to live on. They were emptying the account. Theoretically, you would hope that the police would be aware of those circumstances before filing a charge. But theoretically, if they're not, there is that defence that's provided for within the legislation.
And Section 54E continues with subsection 2 saying that for subsection 1, that the course of conduct was reasonable in all the circumstances is taken to be proven if A, evidence adduced is capable of raising an issue as to whether the course of conduct is reasonable in all the circumstances, and B, the prosecution does not prove beyond reasonable doubt that the course of conduct is not reasonable in all the circumstances. And typical lawyer fashion, we have two negatives in the one sentence, which is a complete nightmare.
Word
Probably,
salad.
and probably a nightmare to translate. So interpreters will probably have a terrible time interpreting that into other languages as well.
That really explains for the lawyers, though, who bears the burden of proving which side of the argument. So if you're raising that something's reasonable in the circumstances and the prosecution can't negative that it wasn't reasonable in the circumstances, then theoretically the defence should hold. But that's yet to be seen how that would be done, and I can't really envisage a lot of situations where that's going to happen because there's things that lawyers do before cases run away at that level where we write letters to the prosecution to say, look, you've got problems. Could you think about withdrawing the charge here? But when the legislation was being debated, it was written into there as a form of protection, particularly for people who succumb to being over prosecuted, certain groups, and it provides a tolerance or an allowance for the possibility that a defence is appropriate in certain situations.
What are the limits to this offence?
Well, there is a double jeopardy rule that applies, and the best way to describe that is that what happened before the start date, which is the 1st of July, you can't prosecute things that have happened before the 1st of July 2024. You might be able to bring them in as context evidence or tendency evidence, but what happened before the 1st of July 2024 is out of bounds for being prosecuted. You can only start the prosecution from the date that the Act came into force. So that's one limit. As Helen mentioned, another limit is this is not going to apply to kids or people under the age of 18. Another limit is it must be an intimate partner. So you can't prosecute mum and dad if you've had that they won't let you go out. And you must have had some level of intimacy, although the intimacy is not defined by sexual contact. So you don't have to be in a sexual relationship to be intimate partners in accordance with the definition. The double jeopardy rule means that if part of the conduct that's relied upon by the prosecutor, so taking your phone, signing you out of all your apps, taking your money, if that part of the conduct is relied upon for a different charge and is run under a different charge, like a stalk intimidate or a common assault, and you beat that, or the person is prosecuted unsuccessfully or to conclusion, the prosecution can't then uplift that same content and run it a second time in a coercive control prosecution. So the prosecutor will have to decide what content they're running for each charge, the coercive control charge, and then the other specific incident-based charges. And you can't rely on the same conduct for both sets.
So it's going to require a fair bit of careful thought on the part of the prosecution as to
Definitely,
what charges
because
they place.
and that's an important thing, because coercive control ups the game in domestic violence charges. What we've had up to date generally carried 2 years imprisonment. Coercive control or abusive behaviour towards current or former intimate partners increases the penalties to 7 years. So it really is a far more serious charge, and that's reflected by the bigger maximum penalty.
What about changes to other legislation as well? There seems to have been a general move towards recognising this pattern of behaviour in other contexts as well.
Yes, so the bail law has changed, the bail legislation has changed, and so some certain offences, including a detain or a kidnap type offence, which carries a 14-year maximum penalty, that then becomes, under the bail legislation, show cause why your detention is justified,
Mm.
and or why your detention is not justified. And so that came into play. And if an accused person is charged with a show cause domestic violence offence and the court decides to grant them bail, they must be subject to electronic monitoring unless the bail authority or the court giving them bail is satisfied that the sufficient reasons exist in the interest of justice not to impose the condition that they are electronically monitored.
I'd like to say that these changes came as a result of the distress out of the killing of Molly Ticehurst in the Forbes area. The person that is the alleged offender in her matter was already on bail. And for the non-lawyers who might be listening here, show cause is the lawyer way of saying, generally speaking, you really shouldn't be getting bail. The starting point is no bail. And so you have to show special reasons or special causes why you should be allowed to get over that presumption against you in the very beginning. And so the government has tightened up the statistical chance for someone with charges of this type getting bail in the very first instance anyway. And the idea behind that is that, again, it goes back to the risk to domestic violence victims, that it's a high risk area and they should be protected.
And the prosecution who appears on the bail application must consult with the complainant or the alleged victim, and they must present that view on the bail application to the court. They must consult with the person.
And or their family as well. So, yes, that's come as a result of the concerns in the Molly Ticehurst case.
Yeah, I guess it's really important for us to mention and keep in mind that these are all real people who've lost their lives and families who've lost daughters and mothers as a result of this behaviour. And yeah, just to keep those real people front of mind. And that's why we're having this discussion and why there's been changes to the law.
Yeah.
And it's across all demographics, all socio-economic groups, all types of sexualities, relationships, cultures. It is not one culture alone. Domestic violence is rife, and domestic abuse is rife throughout the community.
There's also been some changes to the Crimes, Domestic and Personal Violence and Other Legislation Amendment Bill. So this is a lot of the domestic violence offending comes under this Act. And over the course of 2024, this Act has been updated, which is a normal thing. Legislation gets updated from time to time because social norms evolve. So this legislation originally came into force in 2007, and it's been updated again. And the first change was a change to the definition under Section 6A of domestic abuse. And domestic abuse is now defined to include coercive control. And what that tinkering with that definition does is that when an offence under 54D occurs, it is given a little set of brackets at the end of the offence with the letters DV inside the brackets. And when courts and lawyers and police see that, it defines how that charge interacts with other components within the legal system. So if I'm looking at a person, if I'm looking at their criminal history on a bail application, I can see some common assaults, but I can also see some common assaults brackets DV. And I know that those common assaults relate to domestic violence. And so I will then go through and count how many of those they have on their history. And that interacts with the submissions about risk that I can or can't make on bail for that person. It also interacts with how ADVOs are handled, so apprehended domestic violence orders. And the changes to the Crimes, Domestic and Personal Violence Act have also affected what's happening with ADVOs, apprehended domestic violence orders. So they've actually created some new offences relating to ADVOs, and one of them is that you can now have an aggravated breach of an ADVO, and what that means is that the person is breaking the AVO or the ADVO intentionally, and they're breaking it intentionally with the goal being that that causes harm or fear to the person. So that sometimes we would look at that as a far more elevated level of criminality than say the kind of breach which is perhaps there was some contact. The contact is merely just running into each other in a shopping centre, but then there's the type of breach where it's sending messages of quite hateful messages that in a text, or which is another form of contact that potentially breach the AVO. And then also one of the other amendments is that you can now have an aggravated offence of persistently breaching the ADVO. And what we see with these patterns of behaviour is that repetition is another form of perpetration. So people who are getting many messages, they're not necessarily threatening messages, but they're just repetitious messages in the context where there's an AVO that says no contact. That persistence, that harassment of them is and again, it's another elevated form of offending. So these types of new offences upped the penalties to 5 years for this offence, for the persistent aggravated breach, and 3 years for the aggravated breach of an ADVO. It's another layer that the government has put in place with the aim of protecting victims.
What's the new civil protection order scheme?
Well, in civil, there's over the last sort of 8 years, there's been a set of orders that have been in place for people who, say, for example, they've had terrorism offending or they've had child abuse offending. And so there's been a type of order that you can get placed on offenders like that, which will really put obligations on the individual, what we call positive obligations, like you must not go near schools, or you must not hang out with other people who are connected to an alleged terrorism group or a bikie group. And so they're now sort of mirroring those kind of positive obligations on domestic violence offenders. So if a person's been a domestic violence offender multiple times, the government can, or the police can now say, you know what, you keep coming back with the same thing time and time again. We're now going to put an order in place that forces you to comply with stuff, positive obligations, to really intervene in the offending. And that can include things such as reporting, electronic monitoring, place restrictions that are really ongoing for a very long time. So that's, it's called a serious domestic abuse prevention order. And there were some final little amendments as well about that you can now serve an AVO electronically, which up until that amendment had been a way that there was a delay between the court announcing an AVO and then the police going out to serve it on a person in person. So electronic service has closed that loophole.
So then the granting of a provisional AVO can provide, in practical terms, a more immediate protection because of that ability for electronic service.
Yes. Yeah.
An important factor in relation to this new offence and other changes to the law is evidence. And this podcast series is directed towards community workers and support workers who are working with victims of domestic violence and also possibly working with offenders or alleged offenders. What is the sort of evidence and what are the things that community workers can do to support the clients that they're working with if they're trying to assist them in terms of evidence and other steps that they might take that would be useful to a client who comes to see them?
I think that just before I give a story, that the domestic abuse definition and types of behaviours that come under that are things that have, as Hayley touched on earlier, have not always been criminalised, or every time somebody went to the police in the past, they got told that's not a crime. We can't charge them, they haven't done anything wrong. But with the change in the definition of, or the new definition of domestic abuse in the Crimes and Domestic and Personal Violence Act, we've got things like behaviour that shames and degrades somebody, behaviour that destroys property. Well, that's always been a crime, but it is again in the definition of domestic abuse. Trying to control where somebody goes for spiritual ceremonies or cultural practices, things like that, stopping somebody from expressing their cultural identity, things like that. Workers, community workers, if somebody is coming to them and saying, look, these things are happening to me, the community worker can recognize, well, actually, that is in the legislation. That is actually criminal behavior by this partner, by this other person, and encourage the person to keep evidence, take notes, get photos, that sort of thing. And I'll just tell you about a case that I had without obviously identifying the person. Sometimes police end up charging the true victim of domestic abuse. And I had a female client, young female client, charged with murder. She had killed her partner with one stab wound to the chest after he had been throwing knives at her while she was holding her child. And he had been verbally abusing her, and just an hour prior to the act causing death, the police had been called by neighbours for a domestic abuse incident by him. When police turned up the hour earlier, she had sort of told police, I'm okay, nothing happened, I tripped, I fell. So police did not arrest him, they did not remove him from the premises, they left. When police left, of course, he started again, continued the episode, and that resulted in my client defending herself and killing him. Charged with murder, exercised her right to silence, which is everybody's right, not to talk to police, not to explain the self-defense, and not only self-defense in that very moment, but the whole defense and reaction to a whole year-long episode of abuse, abuse, abuse. Police took statements from neighbours who had expressed shock that the person that had died was the male, not the female, because those neighbours had witnessed him dragging her by the hair down the driveway numerous times. They'd heard yelling, they'd heard doors banging. Some of them had had to help her earlier.
They
He had
probably
never.
expected it was going to be her, probably.
Yes, they thought they were shocked because they thought if anyone's going to die, it's going to be her. Because they've heard him, they've seen him. He's just never been charged with this before. And my client, again, young woman, Aboriginal woman, with a child to another partner who was also abusive. And when I asked her, also going through her background, was her father abusive in the home? Was there abuse in the home? She denied it, but I had a feeling that there was more to this because her father knew the deceased, her father knew the partner. There was a drug selling relationship between father and partner. That's how she got introduced to the partner, because he was a friend of her father. And I wasn't sure how that friendship was based, but it was based on drugs. And eventually she opened up to me and said, look, I told you that my father wasn't abusive in the past, but that wasn't true. He was. And I encouraged her to speak openly, not only to me, that's great, but importantly also to the psychiatrist that I would be sending to assess her, with all the material, with all the witness statements of past abuses, with her medical records, where she had turned up to the doctor on numerous occasions with black eye, bruises, abrasions. She'd become pregnant to him and threats to the baby, and she had covered up for him, gave the doctor some other excuse of why those bruises were there. Doctor made notes quoting what she had said. So those notes were then potentially evidence in court if she ever raised prior domestic violence as an issue. Well, then we have this problem where we've got medical notes suggesting another version for the bruises. So she had to explain all of this pattern of covering up for him, minimizing his behavior, defending the perpetrator in a sense. And it took a lot of courage by her, and it took many hours of conferences of her gaining trust, gaining courage to speak out. And in the end, the prosecution encouraged and invited her to make a statement to the police, an interview to the police, which is, of course, a very dangerous thing, because we often do give advice to clients, you've got the right to silence.
Yeah, I've never encountered it. So in many years that I've been working, so it's really extraordinary that you were there with this.
And it's terrifying sitting there listening and not knowing whether, under the pressure of police officer asking questions, an experienced detective, whether all those hours that I've spent listening to her story, whether she's going to be consistent with what she's told me, which sounds very much like a self-defense defense, and it sounds very much like somebody who has been on the brunt of domestic violence for a very long time, starting as a child, where it becomes normal for her as an adult, and wondering whether she's going to be able to trust a male detective as well, to be able to tell him for the first time what she's told me consistently over many months. She wanted me present with her while she spoke to police, which then opened up another legal hurdle of getting the special caution, which is an additional caution. Very much sounds like what, if you listen to a British crime show, what the British police
Yeah, they do them.
give.
Yeah, that's it. I've seen those. I've actually seen that on TV. So yes, that is, you're spot on there, Helen.
So anything that more or less what you fail to say to us
Yeah.
can no longer be used in court as part of your defense. So either speak up now and tell us everything now, or don't try and rely on it later in court. So we had this situation where she had this one chance of recording everything to the police, being grilled by them in a police station, and knowing that this becomes evidence in court to be played before a jury. It was very intensive and emotional. She needed a break, but at the end of the several hours of that recording, the police transcribed it as they do, and then that was a copy was given to the prosecution. We made submission that they withdraw the charge on the basis that she has a full defence of self-defence. It's a defence to murder charge, that she's in fact the true victim here, defending herself and her son. defense of another. And what she did was legally okay and justified under all the circumstances, and completely a reasonable response. This one stab wound was a reasonable response to somebody who's throwing knives at you and making verbal threats.
Wow, in that context.
In that context of a history of domestic violence witnessed by neighbours, etc.
That's an
So,
absolutely extraordinary matter to have worked on.
and
And
so they did withdraw the charge 5 months after we put in the
wow,
request for them to do so. We had a trial date lined up, and 6 weeks out from trial, they made the decision to withdraw the charge. But that's an example of somebody that was charged, who police charged a true victim of domestic abuse, of this constant domestic abuse, or everything he said to her, the degrading comments he constantly made to her, the physical abuse, the excluding her from her friends, getting jealous and controlling when she wanted to see her friends, all of those kinds of behaviors were perpetrated on her over months and months.
it's actually thanks to your thoroughness that the story came out with relation to that client. And that's probably a little bit of the advice that the listeners might take away from this, that it is very often the story of the person who is in the situation that forms the majority of evidence. And people might ask lawyers like us, how can we gather evidence? Well, largely the evidence will be what happened and what you say has happened. Where you can get evidence that matches up to what you say happened, that supports your evidence. So we call that, as lawyers, things that corroborate the account, things that boost it. So there are some really great ways that evidence can be supported or gathered up. There's a couple of apps online that help people who are experiencing domestic violence situations record things that are occurring in a private and non-trackable way, so it can be locked away and hidden in a phone. One is called the ARC app, and the other is called Empower You, which is run by New South Wales Police, and we're not associated with those apps in any way. But obviously, keeping records in any form that support the story of what is happening are things that help. So records might include, if, let's just say, there's some abuse has happened, and it's happened when you're driving through a KFC drive-through, and you will have a memory of what happened, and you might have a photograph of your meal when you drove through the KFC drive-through on that singular occasion. And even though you don't have a photograph of the abuse that happened or a recording of it, that memory is anchored by taking that photograph on that day. So things like that. But then also you might have direct examples, such as, you might have voice memos, you might have text messages, you might have some emails, you might have any photographs, particularly if they're photographs of injuries after something has happened. You might have bank records that show a pattern of money being taken or money being withheld. You might have multiple mobile phones that have been smashed, and you might have to have gone back to the telephone shop multiple times to replace your mobile phone. And then if that supports evidence that the person has broken my phone at least 3 times, you've got the record of having to go and obtain a new phone. There might be records such as someone claiming on your insurance, or making an application for a loan or a credit card without your consent. These are the kind of pieces of evidence that they breadcrumb and support the overall story, the overall narrative of the pattern of abuse. So support workers are really helpful in a way in assisting people that they're working with gather those things up, provide them the reminder to be able to gather up those little clues and give them to the police, or if they're working with a domestic violence lawyer specifically.
Thank you. And thank you, Helen, for that extraordinary story about your client. One aspect of that, I guess, is misplaced victim loyalty. And Hayley, I think you you mentioned previously that that's something that
Yeah, it's really common. So support workers will probably be, some of them will be really across this, that there are psychological impacts that people experience when they've been the subject of domestic violence, and built into the experience of going through it is the experience of safety or behavior that supports safety. So it's very frequently the case that a victim survivor will do things that to an external party really just don't make sense, like withdrawing their complaint, or even worse, making a false story that when I haven't been hurt, I haven't been stalked, we have a really supportive relationship, we just want to get back together, this is a storm in a teacup. And so there's a phenomena called victim support or victim identification with the perpetrator, and it's difficult to manage, because a large amount of energy of working with victims can sometimes unfortunately be spent on assisting them to turn the tables on the behavior that has supported them having safety in a domestic violence situation, which is being compliant or being supportive. So people who work with them need that depth of understanding that that's a phenomena. And alongside that is the phenomena, as Helen touched on, of victim misidentification. So victim misidentification is this idea that victims can also be people who are caught up in the legal system when predominantly they're the person who over time has not been the primary aggressor, and the primary aggressor is the person that the system is now supporting. The Working Committee on Coercive Control is monitoring the impact of this possibility because it really predominantly manifests, there's a concern that it will manifest in Aboriginal and Torres Strait Islander and culturally and linguistically diverse groups of individuals, because when a person calls the police, if they're a misidentified victim, they might have engaged in a lower level form of offending, such as some property damage or some inappropriate language in public. They might be quite highly emotionally charged, and the police who attend and only see that snapshot of behaviour, or they see a recording of some very volatile behaviour, that's that little moment, they see that person as the offender, where if they'd gone into the overall backstory of what has been going on for a longer period of time, it might be discovered that the primary aggressor is not the person that they think it is when they attend on that occasion. So misidentified victims are a vulnerable group that this legislation is aware of. And Legal Aid New South Wales has a specialist group of lawyers, the Domestic Violence Unit and the WDV-CAS group, who are charged with seeking out representation for people who might come under this subset of people caught before the legal system.
Thank you. I think you spoke earlier as well about the support that community workers can provide in relation to reporting, and those legal aid services can provide victims with legal advice before when they're considering making a police report. Is
Yeah,
that correct?
that is, look, domestic violence affects multi aspects of the legal system and people's private lives. There are cross practice issues for visas, there's cross practice issues for housing and civil law and rental rights, banking and finance and those areas. There's cross practice issues very largely for family law. So when a community worker has this person effectively on their doorstep with, in many ways, their life imploding, the community worker is at that critical moment of being able to assist an individual with being connected with other areas where they can receive help. Legal Aid has a free advice service for civil law, family law, criminal law, but we also have a specialist service that deals with domestic violence victims called the Domestic Violence Unit. If listeners are listening from interstate, there's probably mirroring organisations to legal aid in those states. But the WDV-CAS and Domestic Violence Unit are specialist units inside legal aid who are separate. They have firewall protection from all the other areas, and they have lawyers who are particularly trained to deal with people who are the primary victims of domestic violence, who are going through those life implosions. And they have lawyers across practices. They have family lawyers, they have civil lawyers, and they have criminal lawyers that work within that whole area. So community workers can pick these victims up and hopefully channel them into services like ours and other similar services that are present within the state. And also, in that opportunity that they have with them, start the process of educating them so they can seek protection from putting in layers of protection into their circumstances, hopefully.
Thank you. I just wonder if either of you have anything to say about the role of police in relation to the offence of domestic abuse.
I think that it's very important with the law coming in that I would imagine, well, I believe that police are being delivered training. I hope that they are, because it's imperative that the first responders recognise those very examples of misidentified victims, misidentified perpetrators, misplaced victim loyalty, things like that. Probe a bit further when somebody says, no, I'm okay, I'm okay. Don't just leave. When somebody says, no, I wasn't hit by that person, the red mark on my face is just because I bumped into the door. Don't just take that at face value. Probe a bit further. And having that understanding and empathy, when somebody feels that they are being stalked, when they are being treated in these controlling, abusive ways, that the person's actually believed a lot more than just being turned away and being told nothing that the police can do. That's my hope, anyway.
There are some results that are published online by a group called BOSCAR, which is the New South Wales Crime Statistics Analytical Group. And since the coercive control laws came into force on the 1st of July till September 2024, there were 76 coercive control incidences that were recorded by New South Wales Police. And there have been 2 matters that have resulted in charges. One of those 2 matters was resulted in a plea. And that's encouraging because from studies from the UK and from Scotland, this type of law, when it comes in, it's got a period of time where it really does take a little bit of onboarding, and the government put a lot of time and money into into education of police and lawyers and community workers and various other stakeholders. And for us to see those kind of statistics so early on is slightly mildly encouraging. But what was really interesting when I've drilled down into those results from BOSCAR, the Bureau of Crime Statistics and Research, is that the 2 major, like 54% of those coercive controlling statistics related to behaviour which included harassment, monitoring and tracking. That was the more than half. And the other big group, 45%, included financial abuse. Now, you can get coercive control that has multiple parts. So it has harassment, monitoring and tracking. It has also got financial abuse. It's also got shaming and degradation and humiliation. It's also got threats. But I think it's a really interesting statistic to see that it's those little things like the harassment and monitoring that are quite strong red flags. And it really does show you that there's probably quite a high likelihood that a lot of what goes on in abuse comes through technological forms. So I think if community workers are seeing any evidence of that on mobile phones, it's quite a likely indicator that there's stuff's going on in relation to this individual, and the content in the phone is very relevant evidence.
Thank you. I think we've covered a fairly broad area of topics in relation to this new offence. Is there anything else either of you would like to add?
I think that it's very important that we recognise that when people are accused of this, that it's in everyone's best interest that that person is legally represented rather than representing themselves in court. That's not to say that the defence lawyer condones or justifies the behaviour. That is not the role of the defence lawyer. Look at it more that the defence lawyer's role is to ensure that their client receives a fair go, gets through the system in a fair way, that their rights are protected, but also that, doing things in an ethical way so that the person on the other side, the victim, is not further humiliated or degraded through the system. And the last thing that anybody wants is for a person in need of protection or a victim of these serious crimes to be humiliated in court by dragged out, terrible questioning by an accused person. You want the lawyer to be putting up a safeguard against that sort of behaviour. The people should be represented, and because it will save time, it'll be more efficient, and it'll be more humane as well.
Yes, I agree. I really do agree with those sentiments of Helen. For me, I think the part I find so important about this offence and broader the concept behind it is that it actually comes down to a concept of rights. And like the right to a defence at law and representation in legal proceedings, people also have rights in society. And I think what this legislation is trying to do, and in some ways is doing effectively, is it's drawing a line in the sand where impingement on a person's rights to self-autonomy, to being, to existing, is formally recognised as a criminal offence. Everyone has the right to safety and freedom of existence. And when those things are curtailed, it's a wrong. It is a wrong for individuals to have to go through that and experience that. And I think in leading in Australia and also being one of very few countries in the world with legislation of this type, our state has taken a very educated and well-informed leap forward in supporting the rights of every person. So that's my concluding remarks.
Thank you, Hayley. And it's so fitting that they are your concluding remarks because the day that we're recording this on is International Human Rights Day.
Oh,
And
wow.
those rights that you speak of are part of the International Declaration of Human Rights. And it's so fitting that we conclude on that note. Thank you.
Thank you both. Thank you, Helen. Thank you, Bridget. It's always lovely to talk to you both. And
Thank you,
thanks for
Hayley.
today.
Thank you, Bridget.
That's all for this episode. Don't forget to check the show notes for more information and links to different resources mentioned in this episode. You're listening to Law for Community Workers. Catch you next time.